Good morning, everyone, and welcome to Leave Laws and the Overlap You Need to Know About. I'm Vinny Civitello, Communications Manager for the New Jersey Business and Industry Association. With us today from Primepoint is Judy Saylor. Primepoint is an official affinity partner of NJBIA, and as such, you can receive discounts on their payroll processing services and human resource management system. For more information about that, visit us on the web at njbia.org. Few housekeeping matters before we get started. Today's webinar is being recorded and will be emailed to you tomorrow along with the PowerPoint for today's presentation, so be on the lookout for those. If you just can't wait, you can download them right now from the Handouts tab, but I'd also like to draw your attention to Questions tab. Judy would be happy to take all of your questions, so don't hesitate to write them in as they come to you. So now let's get things started. Judy?
Thanks so much, Vin. It's very good to meet you all today. And I'm hoping today we'll clarify some of the latest changes that have been made in the state of New Jersey when it comes to taking leave. So when a person takes or requests a leave, there are a lot of different variables now that we need to consider for that leave they're going to take. Each of these areas becomes either concurrent or tracks after or before. And we need to know the order they need to go in. We need to know what is the potential responsibility of the employer, obviously, and what is the potential responsibility for the employee. When we look at family medical leave, we know, first of all, that it's unpaid. It was established in 1993 to support workers who needed time off for various reasons and wanted to be able to keep their position. Private employers with 50 or more employees on its payroll for 20 or more calendar weeks are required to offer FMLA. The employees that count towards that 50 are full-time, part-time, employees on suspension, or employees on leave. Where some of the tricky part comes in is looking at, are all of your employees in one area? Are they all in the U.S. or in U.S. territories? Do you have additional offices elsewhere? When we look at the eligibility for FMLA, the employee has to have been employed for at least the last 12 months. They have to have worked 1,250 hours in that time. And one of the big captures is that the work site where 50 or more employees are employed within a 75-mile radius. I've seen some clients have to kind of tread lightly when they were looking at salespeople who were across the country. What's that actual work site considered if you're a salesperson in another state? The last piece then, of course, is that qualifying event. And we, all have learned, I'm sure, through family and friends, that the first reason as a qualifying event is for the care of a child. Either you have giving birth, the adoption of, or foster care. The idea to care for a spouse, son, daughter, or parent through their serious medical condition. Someone's having surgery, you're going to be the driver, you're going to help provide care for them, etc. It also covers the employee's serious health injuries. Someone else is going to help you, you're going to take the FMLA. We see a change now in the military qualifying exigency, and that comes in light of some of the recent items that have come through the VA. So when we look at what is actually a serious health condition, it starts with inpatient care. You're in the hospital, you're being treated for some ailment. You are incapacitated for more than 3 days with continuing treatment from that healthcare provider. An incapacity relating to the pregnancy or prenatal care, a chronic serious health condition. And some of the chronic serious health conditions, you would potentially want to speak to your legal department about that, because that list has changed and continues to change as chronic gets defined for folks. Certain conditions that may require multiple treatments. For example, you may have a family or friend who has had to have chemotherapy. It could be a once-a-week event. It could be a once every other week event, and they need to go to a center to receive that care and treatment. You would want to support them, obviously, and FMLA would guarantee their job while they were out for that period. So the entitlements that folks get, we know it's 12 weeks within the first 12 months One of the changes is now 26 weeks of care for an injured military family member or with a serious injury or illness. One of the things that you need to look at is you can require an individual to utilize their PTO to run concurrently with FMLA, meaning they would have to use their paid time off in order to get income replacement during FMLA. So some of the details. It can be continuous, it can be intermittent, it can be on a reduced schedule, much similar to the individual going for chemotherapy treatment. PTO may be required by the employer or requested by the employee. We know lots of folks who are preparing for surgery, and so they know that's going to come in the second or third quarter. They may be setting aside and not utilizing, not taking vacation, et cetera, so that they can use that time during their FMLA. Their group health insurance benefits have to be maintained, and what that's going to mean is the individual is going to be required to send in a check or some payment to cover their employee portion or employee share of those medical benefits. The employee then gets reinstated at the same time in a comparable position. You can require medical certification. There's a variety of different documentations that we have looked at here. And if you can see, each of these forms covers a different either provider or area that one would need to provide notice to. So there's first the employees and employer form is that notice of eligibility, rights, and responsibilities. Then there can be contact with the healthcare provider for the employee's health care issue. Then the family member's potential provider. This is where I always say document, document, document. You need to and want to be a part of what we consider that interactive process. And what that's going to do is that keeps that line of communication open between you and the potential healthcare provider so that you're aware of what else is needed and the employee is aware of the tracking and what you're doing. You do need, for notification, to have this hanging up on that conspicuous poster that we all have. If you're part of the Primepoint poster replacement program, you'll know how often it changes and a new one gets sent to you. And you want to make sure you're choosing the correct form and then having that documented, all of your communications back and forth with either the employee or the medical provider. Next, we move into New Jersey Family Leave Act. And this just changed July 1, 2019 here. It is still an unpaid support, but instead of being for 50 employees, it's now 30 or more working employees for the 20 work weeks or more. This does include out-of-state employees if the home office is here in the state of New Jersey. All public employers are required to do this. It does offer that job protection, and as I said, there is no income replacement for them. The eligibility for this is the employee has to have been employed with you for 12 months. Here they only need to work 1,000 hours in the immediately preceding month. And again, we look at qualifying events. And here's where, if you're looking at a pregnancy, the bonding with the baby is that next phase after your FMLA would end for your pregnancy. This does include having a child through a gestational carrier. The placement of the adopted child or foster care to care for a spouse, son, daughter. We already see, if you recall from the New Jersey sick leave, which we'll look at, the new definition of family. And it's that part of the equivalent of a family member. This is very tenuous in terms of responses to people. You need to be very careful how your direct frontline managers respond to people about needing to take off to take their neighbor to a doctor's appointment or whatever that concept is. I've said several times in different presentations, I've talked to 2 law firms who said if I tried that with my dog, who is my fur baby, they would go to court with that just for grins and giggles to see how it would work out. The entitlements that they receive is again going to be another 12 weeks. We're now up to 6 months of protected time off. It can be consecutive, it can be intermittent, it can again be that reduced leave. You can require the exhaustion of PTO, but that would need to be in your personnel policy. One of the things that you need to look at is in your personnel policy, how are you defining the interaction of any benefit you're giving connected to any of the leaves? We're in a day and age where we need to spell that out now before the attorneys spell it out for us. Again, the group health benefits need to be paid, and the employer share or employee share needs to be sent into the organization. You are expected to reinstate that person at the same or comparable position. And again, medical certification and documentation may be required. So what's the employee obligation? If I want to take intermittent leave, I need to give a minimum of 15 days notice. In the past, I had to get approval for that. With the new concept, there is no requirement of approval. You can do a consecutive leave for serious health conditions for a family member. That notice is supposed to be reasonable and practicable. So what does that mean? A family member, unfortunately, is involved in a car accident. That's probably going to fall into the category of emergency, and I'm going to notify you as soon as possible once I know what's going on. You know, mother, son, daughter, father, your reaction to that, needs to be very standard in how you respond as the organization, but remind yourself to keep the human in human resources. So the NJFLA has specific notice requirements. If you'll look to the right, that's a poster of the 5 points that we're required to share with our employees. You should have it in, again, your handbook and your personnel policy. New Jersey wants an annual distribution of the notice, so either utilizing your communications platform or the intranet or an employee experience opportunity, you need to have that posted every year, and you want those employees signing off or acknowledging in some way that they did receive it. There is no official form. I have spoken to several different attorneys on this, and many of your attorneys have a standardized form that they have created to protect you in the event that someone does require NJFLA and to have you document the appropriate needs. For NJFLA, we want to stick to following the best practices. Again, document, 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 interactive process, patience, determining how long can we actually survive without this individual. It could be a key position, and you've got to look at what are my options with that. Now we move into the New Jersey Security and Financial Empowerment Act. This is a very specified act that, again, starts with 25 or more employees for that 20 or more work weeks period. The employee needs to be employed for 1 year and have worked for 1,000 hours, and they're going to receive 20 days per year for this. What this relates to is an employee who unfortunately suffers from a domestic violence or sexual assault act. Again, it is spelled out, but that new family definition is going to be creeping into everything there is New Jersey. So be mindful of that in your personnel policies. The items that are defined as being from domestic violence include all of these. Some of the things that we are seeing occur in the workplace are things along the lines of terroristic threats. That could be an employee to employee, employee to an outside person. If and when these were to occur, HR should be notified. There needs to be that tracking. 1, to support the employee, and 2, to support if there's other steps that need to be taken. It may be recommended that an individual considers NJ safe so they can take care of the needs that they have in that period of time. The qualifying reasons that we would allow them that time is, first and foremost for medical attention, to recover from injuries. But some of the bigger ones are going to be those obtaining services. Maybe they need to move. Maybe they need to move quickly. Maybe they need to be in a shelter. Are they in need of counseling? Are their children in need of counseling? What are the things that come up that require us to, not be at the office and give us the opportunity to make a good difference and prepare or take care of our needs? So the entitlements, as we said, was 20 days in a 12-month period. This can be consecutive or intermittent. The tough part here is if it's an ongoing issue, are you going to do the 20 days and then are you going to allow them more? And I will counsel you that if you do for one, you do for all. It doesn't matter what they feel or what they identify as their domestic occurrence. You need to do for one and do for all. The intermittent leave must be no less than 1 full day. It's not a half day. It's not 2 hours. It's that we as employers are trying to manage this time now in this new day and age as things are changing. You may elect as the employee to use PTO. We as employers can no longer require you to do that. The leave may run concurrently with FMLA or NJFLA. And again, we're working to reinstate the employee to the same or comparable position. The documentation for NJ Safe is obviously going to be much different than the others. There could be a restraining order. There could be letters from different law agencies. There could be medical documentation, which again, those are very private matters and need to be kept confidential. No matter what the employee says to everyone else around them, leadership and staff should not be the ones sharing that info. And potentially any documentation from a social worker or other professional. So those individuals that can provide it are going to provide that, safe to work type of concept, much like a doctor would provide if you went out sick or injured. There is, like our other opportunities, anti-retaliation requirements. Employers are permitted from discharging, harassing, or otherwise discriminating or retaliating against an employee. I would be shocked if anyone would do that, but that does not mean there isn't one person who makes that mistake or manager who speaks outside of what they should be doing. You want to make sure that this is very specifically laid out in whatever leadership book you give to folks or personnel policies. People need to know what their requirements are. The fines start at $1,000 for the first offense and $2,000 for the second, $5,000 for the third, and all subsequent events. If you are at that stage, you need someone to come in and really train your staff. Something is wrong and they're speaking in a way that is not representative of you and your company, I'm sure. Again, the New Jersey SAFE Act is looking for that conspicuous posting. I actually did go and look at our poster just to make sure I wasn't crazy, and there it was, down in the bottom middle. You will see all of the new ones on there that we've been dealing with this year. As of July 1st, employees are now able to take NJ Safe as well as the wage replacement benefits. So they can utilize NJFLA, which we will talk about. They can choose to use their PTO and again run concurrently with FMLA and NJFLA. When we're doing that, you need to identify which of the leaves they're actually using and document accordingly to be sure that you've got the documentation backup to support what they are utilizing. The next part that we're looking at is the American with Disabilities Act. And though there's not a lot of materials out there, you'll know it when it comes up. The reason being is that there are times that someone will go out on FMLA or NJFLA, and due to no fault of their own or circumstances beyond their control, they may now have a disability, and they are now eligible for this. So in your process, in your interactive process, you want to make sure that you're covering this base in the event it's going to be occurring in week 25 or 26 of that time frame with your employees. It applies to all employers with 15 or more employees and all public agencies, as we know. The eligibility is defined as one who has been disabled, having an impairment that substantially limits one or more major life activities. The list is much broader than I thought. However, when I read all of them and researched, it all made sense that those should be there. However, there are very specific accommodations that can be done for many of these items. Obviously, for deafness, there is interpretation. There are phones that are very specific for that. There are tools that are very specific for that. Blindness, of course, diabetes. There's no doubt in my mind that we all know potentially several people that have diabetes, and accommodations for that can be very clear. You know, opportunities for doctor's appointments, you know, more trips to the bathroom, you know, the opportunity to walk once, twice a day. There's a lot of different opportunities in there. You will see, and one of the ones that struck me is autism. And that strikes me because right now I have a child of my own, and though he does not have autism, many of his friends are on that spectrum of some sort. And I do think by observation that going forward, the next two generations that get into the workplace will potentially have those types of accommodations for autism. And what are they going to look like? I'm not sure. You know, is it going to be tactile issues? Would it be attention issues? What is it going to be for them? And how are we now going to support managing that and making sure that they have what they need so they can be successful for us in the workplace? We know that some of these issues are kept quiet by people who may suffer from them, or just may not be public knowledge. Many people live with MS for a very long time before it starts to impact them, or at least impact them in the workplace. So with care and the opportunity to be accommodating to an employee, you could have some fabulous teams that work for you and will never have a blip because you provided the accommodations that they need to accomplish their jobs. There are, however, items that are excluded, and these conditions have what they call guidance on the federal website. And there are some items that are very specific in their guidance, but now there are others that don't offer any guidance. We know that compulsive gambling has fallen under addiction at times, and I know of several companies who offer an individual, if they come and acknowledge the fact that they have that addiction, can receive some support through counseling or assistance from their health insurance benefits. You know, the opportunity to help someone change something in terms of gambling, alcoholism, etc., is a positive in this day and age. Some of the others, however, they would never connect necessarily with counseling, for example. The opportunity for someone to discriminate against somebody for a physical characteristic, you know, eye color, hair color, left-handedness, etc., sounds odd in this day and age. However, it's really not. If you look around, you will see that folks do it in a joking kind of way. It's not a question of the person can't do their job, though. However, it could lead into other more hostile opportunities if you're not careful. So the ADA can require an employer to grant medical leave under certain circumstances. The employer, however, does not have the right to set that maximum amount of leave. Now, this would be a leave unpaid if the rest of their time has been exhausted, or it is going to run concurrently with FMLA or NJFLA, but it could go beyond either of those. It has to be addressed on a case-by-case basis, and that case-by-case is right back to that interactive process. So some of the questions you want to think of is, Can we provide enough leave that wouldn't impose undue hardship? If in your company you have one accountant and that accountant, it now needs to go out on leave for 6 months or 8 months or have surgery or had a car accident, what can you do? Now, obviously, we have many, many great clients and businesses out there that are able to support substitutes, basically, temp services, professional temp services, where they have folks with skills like accounting or, human resources, and they can come in and support the organization in getting it through that phase of time. But what would be your substitution plan? Lots of us in HR say you need to have a succession plan, but do you have a substitution plan? School districts have to do this. Certain types of positions need to do this in labor and management. For most of us, we don't think about that part. And God forbid someone is ill or someone is in an accident. Now what do? You want to have a plan laid out in advance as to what you might do. Yes, consider it succession planning, but on a temporary basis. If you are aware of temp agencies, meet with them, contact them, get to know them. Will they collaborate with your style? If they collaborate with your style, keep them on speed dial. You don't know when you might need something. For ADA, we use what is called the Reasonable Accommodation Questionnaire. Lots of you have really great job descriptions, and you put the items in that job description that say, must be able to lift 50 pounds, must be able to sit at a desk, must be able to stand on their feet for X amount of time. There are times that we have those ADA requirements in there, and they might not actually have anything to do with the job. So we want to be careful. We want to make sure that we have legitimate reasons for it before we end up in court, of course. Again, the employer needs to go into that interactive dialogue. What do you need? Well, I need to be able to take a walk every 15 minutes or 15 minutes every hour for X number of days as I am doing PT or my therapy or what have you. Can we accommodate that? Sure, because that individual's going to still be connected to their work. They're going to be able to do it, and they're part of their process in bringing them back into the workplace and having them still be successful with us. Now, the notice, again, is on that lovely poster that we all have either in a break room or in the lunchroom. It needs to be accessible to individuals with disabilities. If you have individuals with visual disabilities, you need to get more than just a poster. If you have folks who are in a wheelchair, it needs to be hung in a place that they can read it from. Sometimes we don't think about those things because we're thinking, oh, got to get the poster up. But when it suddenly is sitting in front of you, you're going to go, oh, shoot, wasn't even thinking about that. We think about those things in the construction of new facilities and bathrooms, etc. We've got to think about it in terms of these other more ethereal talking points like policies and such, and make sure we've covered all of our bases. So the next one we're going to talk about is the New Jersey Law Against Discrimination. With the addition of the Diane B. Allen Equal Pay Act, NJLAD has become stronger, okay? There has already been one of the first court cases with us, and it was Pareto versus Morgan Advanced Materials, if you want to be a geek like myself and go look that up. There was no interactive process for them. There was a discrimination against her, a wage discrimination, and we know that that has now become very forefront in the area. If you are asking the question, if anyone in your organization is asking the question, how much did you make at your last job, you need to not let them interview. The question can be phrased, what would your expectation of a salary or hourly wage be? You need them to give you the information, not ask the question. That can get you into a lot of trouble with this. NJLAD applies to all employers, regardless of the number of employees. Employees must have worked at, or the alleged discrimination must have occurred within the state of New Jersey. So my company is in Pennsylvania, but I am a sales representative in New Jersey. That qualifies me for this. if I find that there is an issue for me. NJLAD uses a much different looking list of disabilities, okay, and they correlate directly to the ADA, but there are additional ones in here that ADA is not looking at yet. Some of those are looking at the psychological, the developmental disabilities, autism on all spectrum disorders. So we need to know what we're dealing with. Is something an ADA issue? Is something an NJLAD issue? Is it both? Do I now have to look at two different, tracks that I need to accomplish a goal on? Now with NJLAD, a disability now includes affected by pregnancy. Go ahead, you can all giggle, I did too. It is defined to include pregnancy, childbirth, and any of the medical conditions related to pregnancy or birth. What could that mean? Gestational diabetes, elevated blood pressure, lots of different items occur when we're working to bring a little cherub into the world. If the employee requests an accommodation because their physician said, fill in the blank, then we need to look at that even if their pregnancy is quote unquote normal. Normal accommodations are things, as you see on the list: bathroom breaks, break for increased water intake, periodic rest. Personally, I think they should bring in a massage therapist and we'd all be a lot happier. These accommodations must be provided unless the employer can demonstrate an undue hardship. Modifying a work schedule, unless that schedule has to be done at that very specific time, is potentially an easy option that we could do. Lots of times, coworkers are more than willing to split hours, change hours, as long as they're not taking the short end of that. So NJLAD can require us as employers to grant medical leave under certain conditions. Again, there is no set period of time. What can we do in the meantime? Again, what is your substitute plan? Who's going to fill in for this person for that undisclosed period of time? Under LAD, a qualified individual with a disability may take off time if that is the reasonable accommodation. Okay, do I need to work a shorter day? Do I need to work 3 days a week at the office and 1 day a week at home, or what have you? 2 days at home, 3 at work? Again, it can't do that undue hardship to us. And NJLAD is not an income replacement opportunity. We have seen NJLAD require an extension of the 12 weeks, but again, here's that interactive dialogue, and we know that being interactive will save us when and if someone were to file against us for it. So now we get to the income replacement considerations. And I have to admit, this slide and another slide came from the wonderful Connell Foley attorneys. We know the lines that go for someone who's going to be out of work, right? So an injury at work is workman's comp, care for family members, family leave. We know these by rote. What we are not fully aware of at this point is the changes that have been made and what are the regulations from the state behind those changes. We haven't seen those yet. So the first one I'm going to start with is PTO. And as we all know, it's not legally required in the state of New Jersey. Paid time off, holiday sick time, not required other than New Jersey sick leave. In court cases that I reviewed, if you promise it, if you say, oh yeah, you can leave every Friday at 2 o'clock in the slow season, you are going to be required to grant it. Okay? You're telling that person they can take the time off and you're still going to pay them, you're not docking their pay, you are going to be required to grant it. You are making it a policy without even putting it in writing. You need to review your policies and what does your policy control? All right? Days, PTO time can be used for, fill in the blank. PTO is paid out upon separation termination. PTO is not paid out upon separation termination. Sick time can be used for, what are the number of holidays? Okay, we get off this day, this day, this day, this day. The Friday after Thanksgiving is not a holiday for some folks, right? You have to define that in writing and make sure that all employees understand that. And the day you give somebody off that Friday after Thanksgiving, you're now going to have 24 people all requesting off on that day because you now made it part of your everyday work, your policy without writing. So looking at PTO and the state requirements on it, it must be in your employee handbook or personnel policy, whatever you choose to call it. You need to, depending on how you hire your staff, have it in the employment contract, have it in the offer letter, and if they're a union group, it needs to be in that CBA. If it's written down, it gets remembered. As soon as you venture outside of those things, someone's going to question it. This year alone, in the last actual 12-month period, there have been at least 8 different things that came out that should have made you pause, go get your personnel policy, and start going through it and looking at those items. I am still reviewing for folks personnel policies. You've got to have these changes in there, and staff all, not just new, need to sign off that they've received it. If you need to print it for your population, print it. If you can put it electronic, use it in that communications opportunity. Then we move into the much anticipated, of course, New Jersey paid sick leave. Again, all employers down to 1 employee. It has already taken effect. Folks can accrue 1 hour of paid sick time for every 30 that they worked. When the date of hire is what drives when that 120 days starts for the employee. New employees shall be eligible for use at the beginning of their 120th calendar day. We dealt with this for months last year, trying to get it to a point where it was manageable for clients. All the employees that you see here are covered, full-time, variable hours, seasonal, temporary. Temp agencies are required to provide this to the employees that they send out to you on a temporary basis. You're not required to. Student workers, you know those wonderful young people you bring in for internships from all the colleges? They're entitled to it. We saw a lot of stumbling blocks with seasonal employees. All those young people that worked for you last summer, once their period of time ends, you potentially want to have a 6-month break in service from them. If not, next summer, they're going to be eligible to use that time. And when I say 6-month break, I mean you can't hire them to come back the week of Thanksgiving for the, specialty event you do with kids, or the Christmas tree lighting event where you're going to have all the young people handing out hot chocolate, and you're going to pay them for that time. They need to be inactive off of your payroll for 6 full months, and then that time honestly evaporates. And is it being mean? No. They are a short-term employee who may only be with you 2 or 3 summers. If you are feeling dramatically generous, you can leave it there. Let them utilize it. There are agencies, however, who just can't do that. They couldn't have 6 camp counselors calling out on a Friday, the last 2 weeks of summer camp. The employees who were excluded from this are, construction industry, anyone under a collective bargaining agreement. I've had a lot of pushback at times from municipalities and some folks because they're quote-unquote all under a collective bargaining agreement, but they're not. Your summer camp staff are not under collective bargaining agreement. Temp folks are not, temporary employees, not from a temp agency, but temporary employees are not under a CBA. Employees you bring in that don't get into the CBA. Sometimes this is secretaries, front desk staff. There are other positions around you that are not part of that CBA. You have got to think about that, okay? Per diem as it relates to hospitals and healthcare employees. And how this has been explained to me after several conversations with the state was anyone who works for an agency that if you went on the Department of Health website, they are categorized as a hospital. Enough said. And if you are categorizing correctly, you need to get that changed. Uh, it does not include employees who are public employees already receiving their sick leave. So again, accrue, use, carry over 40 hours of earned sick leave. I've had several calls in the last 2 weeks from clients who are saying, well, when do I have to pay out the New Jersey sick leave? And my response is, you don't. If you put it in your personnel policy, yes, you do. However, if your personnel policy does not say, I will pay you out unused sick time, all staff are allowed to carry over up to 40 hours of their sick time. Okay? But you're concerned about them having 80 hours. Doesn't matter. They can only use 40 hours in a year. At the end of that benefit year, the other 40 hours is going to evaporate because you're only allowed to carry 40 hours. If they take their time, you have to pay them at the same rate of pay with the same benefits that they normally would earn. Now, this gets tough when you might have somebody who has multiple rates of pay. This is where that 7-day look back came in. If you're unfamiliar with it, email me and I'll send you some info. You can run reports through most of your payroll systems that can clarify you what the rate should be for that person. We did try to lobby at the hearing for this, that whatever the shift is the person called out for should be the rate that they should be paid for that, but they just weren't buying it that day. We're back to, again, our 5 big reasons, okay? Treatment for self, treatment for a family member. This is where that new crazy definition came in. And though I kind of agree with it, it is really hard on employers, and that's not what this should have represented. Time needed as a result of a family member's, status for domestic violence. That, again, that goes to NJ-SAFE for the employee or for the family member. Time when the workplace, school, or child care is closed. So when they call for a state of emergency and they close areas, that is what that is pertaining to. If the township manager of your town closes areas, if the school district closes areas, then you can take a New Jersey sick leave day because you're going to be at home with the kids. Time to attend a school-related meeting. Folks want to go, oh, I'm going to go see my kid's basketball game. No, you're not. If you you will get a note from the teacher or an email from the teacher, a note from the principal, a note from the guidance counselor that says your presence is requested at, because we need to have a conversation about your little cherub. Those are the items that you could take a New Jersey sick leave time for. The recommendation is, of course, take it at the end of the day so that, you and the guidance counselor or principal or whoever it is has the time to sit down and discuss what's going on and make your corrective actions as you can. Some of those details, we all want to use anniversary date. We can't use anniversary date. It is benefit year. It can be January to December, it can be February to January, but no matter what, it's 12 consecutive months. That definition of family. Blackout dates, which I'm finding lots of clients didn't grasp, and so you want to look at what are the items in your organization that are days that it is an all skate and everybody needs to be there. If you're a tax agency, is it the 3 weeks prior to April 15th? If you have a fundraising special event that is an evening gala, the 2 weeks prior to that could be blackout dates because you need all of the staff engaged in what you're doing. Do folks need to bring a doctor's note? Yes, for the 3rd day. If you have a policy that is there would be a write-up for, a no call, no show, you can't do anything about that until you get past those first 40 hours. When you get to day 6, that's now day 1 of the opportunity for you to write them up. If it says 3 days or 1 week and then you're written up, you're at 1 as soon as those New Jersey paid sick leave days are taken up. Time needs to be given to you, or notice needs to be given to you, practical or reasonable. Again, it's the same as the others. There can be no retaliation. I already talked about the carryover payout. Front load. I'm not sure why anybody would front load it. I don't know that it benefits you. And on occasion, it doesn't necessarily support your employees, depending on what they do as a job. Payout upon separation. Again, what's your personnel policy say? If it doesn't say anything, you need to go do that policy now and have everybody sign off on it. That could be a kicker because we're in November, almost December, and for a lot of folks I know, benefit year is ending December 31. Transfers within your organization. If I'm just going to another department, but I'm still under the same parent company, my time follows me. I've earned that time, that's going to stick with me. And then, is it actually PTO? If you opted not to add New Jersey sick leave, but you said, nope, our PTO covers it, you have to, one, allow them to use that PTO for any of the 5 reasons, and you can't have the typical PTO restrictions. I need X number of weeks notice. I need, you can only use it for my spouse, who works for a very large organization, he's required to give his time off the July prior to the next year. They couldn't take that PTO and say, oh, well, that covers us for New Jersey sick leave. And they weren't going to change that PTO because he's under CBA. So they added another whole 5 days of just sick leave that they get to accrue. The penalties, your first offense is $250. I really like the 10 to 90 days in prison. And if you saw any of our previous presentations, I kind of wanted to know who's getting the time in jail. Is there television? Can I read a book? Can I get a nap? Can I get the TV remote? I would take the hit for us so I could get some breaks. I would come out like a size 6 by the time I was done with all the exercise I would be doing. Notification has to be, again, in a place where everyone can see it. And you should all remember there is the notice that was sent out by the state. Actually, it was just posted on their website. But you need to provide that to every new employee who comes in within the first 30 days of them working for you. Now we're moving into NJTDI. And again, we know it's funded through your payroll taxes. It's a benefit provided by the state for your employees. Eligible employees are those who are disabled in some manner. Okay, and during this, you can't take workman's comp if you're taking TDI. It doesn't work. That's a redundant opportunity there. It is a weekly benefit that is equivalent to 70% up to a maximum of $670, and that's pretty much it. We know for temporary disability, there's categories that you have to identify that say, yes, this person should be out, all right? Pregnancy is the one that usually comes to mind because that's what a woman would take when she was going to have a baby. Workman's comp is a job-related injury or illness. It is what's considered a no-fault insurance program, all right? And there is no job requirement to save that person's job. You do not have to restore them to the same position they were in. It provides for medical treatment, prescriptions, hospitalization. 70% of the wages again, and permanent disability compensation to employees who have suffered that. There is a death benefit for dependents of the worker who have died as a result of their employment, and that's going to be looking at based on their wage. So, the New Jersey Family Leave Insurance now. There is no minimum number of employees, again, funded by payroll taxes. You cannot take NJFLA at the same time you would be getting NJTDI. Again, redundancy to them. The entitlements for this have changed dramatically this year. We're up to an 85% of wages, up to $860 a week. As of July 1, 2020, they get 12 weeks of pay. The intermittent leave went from 40 to 56 days available to them, July 1, 2020. This is big, and this makes a huge difference in what we see for employees. So the qualifying reasons for NJFLA, again, care for a family member. NJFLA is not for me, it's for everybody else. It's for the people around me. My child who's just been born, the first 12 months, the care for a foster child or the adoption of a child. And then an individual, like we said, who needs to take NJ Safe. The details. There is no job restoration with this. We do not save your job. There is no more 7-day waiting period. It starts as soon as you apply for it. You can have an employee who has multiple jobs who's receiving NJFLA benefit from one job while continuing the other employment, which is an oddity. However, I've seen it done, and it's typically variable hour employees who are doing that. It prohibits employers from requiring employees to utilize any of their available time off before they start the NJFLA. So here's an example of someone's time off and what that would look like. You can see the beginning of the date of the injury, and it goes out that first 12-week window for workman's comp, okay? They get FMLA because it's their injury, and they get workman's comp because, again, it's their injury from work. Once they're outside of that 12 weeks, there is no FMLA. However, it is still payable by workman's comp. The thing you need to be careful of is the other items. ADA, NJLAD, what is your potential risk if you start the process of trying to either bring this person back in or trying to remove them? You have got to look at what that is going to do. Here is pregnancy, which is the one that I've kind of been bringing up. You start with the day out per the doctor, which is 4 weeks prior to the delivery. When you go out, you start first on FMLA, and you're on NJTDI because you're the individual that's disabled. This goes up until that 12-week period. Well, then we get into the care of the child, right, where we're now, it's not my own serious condition, but it's now my child. So we're going to have this crossover of FMLA and NJFLA, and now NJFLI tips in. We keep moving forward, and we're on NJFLA and FLI. Once we get outside of that, those 22 weeks, 22 to 24, you run the risk of having ADA brought up of NJLAD. An employee now who goes out for pregnancy can be out 6 months with job protection with pay. Can you figure out how to replace that person for 6 months? And if not, start trying to figure that out. The leave income best practices is really train your staff, train your managers and your supervisors. Don't let them make a mistake and deny something to someone that they are legally required to give them because they didn't know. Look at things as a difference between leave laws versus income replacement. They're not married together. They can be concurrent, but they're not married together. Just because you file for FMLA does not mean you're generating any income. And some employees don't understand that. They think that those go, oh, I only have to fill out one set of forms. I don't have to do anything else, right? For FMLA, as soon as someone comes to you and says, I have to have surgery, I have to go to treatment, my mother has to go to treatment, say to them, I'm really sorry to hear that, as you're getting out the FMLA packet for them to complete. You are now required, as a 2019 change in the law, that if you see it as FMLA based on the criteria, you must act on that. Again, for NJFLA, there is no form. You need to get one. Remember the definition of family. New Jersey sick leave, track the 5 reasons. If someone's grandmother has passed 5 or 6 times, you have a different issue going on than what this person is saying. Everyone's eligible for it. Find your substitutes. What does that mean if you're going to have, you can no longer make the employee find their substitute, so what's it going to mean for you to have a substitute for them? ADA, reasonable accommodations, and that interactive dialogue, okay? The interactive dialogue is going to be the thing that helps you deal with the changes that are occurring. Who's going to train your staff? Find a qualified HR person. Contact your attorney. Have someone come in and do a presentation for them so that they understand the pitfalls here. Centralize that leave function. It should be in one department who holds it, who handles tracking all the documentation, tracking all the doctor's notes, tracking all the phone calls, keeping copies of all the emails, keeping all the records. one place, so that you don't run the risk of not having something where it needs to be when and if a suit comes. You need to have consistent and clear policies, and this sounds like a no-brainer, but I've read a lot of policies lately, and I got to tell you, sometimes we think it's English and it's really not once we're done with it. We've confused acronyms at times. Make the distinction for FMLA and NJFLA in your personnel policy. What interacts? Make it clear for your PTO. What can it be used for? Again, do for one, do for all. And the last piece is track your metrics. Sometimes we have been asked, what did it cost me to have him out for 3 months on sick time, on workman's comp, whatever. Track the lost time, okay? Track your costs. You can then turn around and answer those questions, and then you can see, you're going to look at trends. Is this a department thing? I gave a presentation to an industry last week, and we discussed the fact that they felt like when one person in the department figured out how to get time off paid, etc., suddenly 6 other people in the department knew. And, we kind of determined the text message went out and rolled around the building, okay? Track the abuses of it. Is it a certain department? Track the productivity. If someone's out for leave of any sort, but that department is still kicking butt and making their goals, maybe you're overstaffed in that department? I'm not sure. Google was able to improve their return rate of maternity leave folks by 50% by reducing the opportunities where they didn't get communicated to. A lot of times leave, again, is that interactive process. If you're out on maternity leave, at a certain point you really love to talk to adults, that should really happen for you. So, any questions?
Absolutely. I'm going to give everybody a second to type in anything they have. We have a bunch here already. While I'm doing that, I'm going to remind people about the handouts tab. I get a lot of questions about how people can download the slides. So just pull out your handouts tab, and they're right there. And then there's the questions tab. If you haven't typed a question yet, feel free to do so. I know we're coming up on the 12 o'clock hour now, and people may have lunches, they may have meetings. By all means, if you have to go, feel free to do that. Everyone who's registered for this webinar will be receiving the full recording of it tomorrow afternoon, so you won't have to feel like you're missing out on anything. But with that out of the way, we'll go to our first question from Maureen, who asks, is a medical certification required, or can a doctor's note suffice?
Doctor's notes can suffice. It really depends on what the rest of the situation is. Should this person, have a secondary evaluation or be restarted for their job? Is it driving? Is it driving a forklift? Is it lifting heavy objects? That's where you may want a medical certification to prove that, yes, this person can come back to this role.
Okay. Kathleen asks, can we require them to use PTO under NJFLA? It was my understanding that we can give them the election to use it or not require them.
Yes, you can give them the election to use it, but they do not have to take that. Excuse me. That's your choice. You can require it, or they can request it, like they want to use it because they don't want to venture into other things to take that time off.
Okay. Cynthia has a question here that says, are work-study students from colleges entitled to this?
Yes, that's that student part, and that they're entitled to New Jersey sick leave. Even though their work-study depends on who they're working for, okay. But yes, I teach for Rider University, and they did a whole giant presentation with all of us adjunct professors on the fact that student workers were eligible for NJ paid time off, and their hours need to be tracked differently than they had been in the past.
We have actually a related question from Eliza, who asks if unpaid student interns are eligible for earned sick leave, or do they have to be paid in order to be eligible?
Honestly, that's a great question. I haven't seen many unpaid opportunities lately. One would think it's not about your income being generated, it's about the hours that you're working. So I would think yes, but the reality is they're not going to get any income out of it. Not going to get a paycheck to make up for the time they lost.
Okay, Melissa asks, if the NJFLA notice must be distributed every year, is it okay to have new hires sign it then?
Absolutely. When the new hires come in, have them do it right away. Put that in an onboarding process, have all those things, and do that onboarding digitally, put all the forms in, have everybody sign off they've received it as soon as they get hired for you.
Bill asks, for NJPTO, if our employees are covered under a construction CBA, do we still have to issue the state notice to new hires?
I'm not sure what you mean. The PTO is not a requirement. Their CBA probably is tracking their time off as it is. So the CBA would stand on top of anything else that there would be.
Okay. Another one from Melissa, who asks, NJ-LAD salary question. When asking applicants what is the range you will be looking for, many times applicants volunteer their last salary. What do you do then? You said if they tell you your last salary, don't interview them.
No. What I said is don't ask up front what was your last salary. They can volunteer the information. That's up to them. You just can't ask it in a way that is coming off of that. And the reason for that is we've seen over time, a woman gets hired in her early 20s out of college, and she was starting at a lower rate right off the bat than a man. Fast forward 20 years, she may be making $30,000, $40,000 less than her counterpart, only because she was hired at a lower deck than he was. And so you can ask for a range. The next generation that's coming out is very versed in research, and they're going to figure out what this pay could potentially be. So they're going to have a range in their head.
Okay. Ava has a question that sounds like it might have been off of one of your examples, but she asks, how can someone be out for 6 months with a pregnancy?
They would be, hold on, we'll go back. Maybe. So they're out their first 12 weeks because it's their own health condition, and then they get 12 weeks for care and bonding with the child. So that goes to 24 weeks. During the first 12, they're getting NJTDI. During the next 12, they're potentially getting NJFLA.
Okay. Belle asks, how do we handle a situation where an employee tells me that they will be going out for surgery in 2 months, but they are required to get their completed cert back within 15 days?
Say that again?
She asks, how do we handle a situation where an employee tells me that they will be going out for surgery in 2 months, but they are required to get their completed cert back within 15 days?
Meaning they're going to go out on leave in 2 months?
Yeah, I guess so, because the surgery would be within 2 months.
Within the 2 months. That, I'm not sure. The 15 days is just a standard that we've seen.
Mm-hmm.
But I would think as an employer, depending on when they come and tell you, because honestly, they could find out 2 days before they have to go in. One never knows. You could be flexible on that. And I would also think that once they know, their doctor's probably not going to let them leave the office without having something in writing for them. And honestly, in this day and age of electronic referrals and all those things, I would think that it's probably a blanketed form that they're going to put in what is the issue there.
All right, this is a follow-up or maybe a related question to something someone asked earlier, but Jennifer asks, can you require a doctor's note / medical certification?
So for things like New Jersey sick leave, you can only require a doctor's note after 3 days. Of 3 consecutive days of being out. So Monday, Tuesday, Wednesday, I call out sick. When I come in Thursday, I need to bring a doctor's note.
Okay. Pillar asks, under intermittent bonding, what is the least amount of time an employee can take? 1 week? If this is correct, what is the employer notice requirement?
Well, intermittent is going to be iffy depending on what they're actually looking for time-wise. So is it they want to work half days, childcare issue kind of thing. If they don't want to take, we'll say their whole 12 weeks of NJFLA, are they going to take 4 weeks? Like what is their need for it actually, and then how much time are they going to use? If they want to take, and we have a client where someone's doing this, where the spouses trade off right now, and so he's out Monday and Tuesday, and then the spouse is with the child from her organization Thursday, Friday, and someone in the middle is watching them on Wednesday. Those two employees are now taking off intermittently every Monday and Tuesday, spread out over X number of weeks, so they can utilize all that time.
Okay. Heather asks, just to confirm, if my employees work 40 hours each week times 52 is 2080 hours divided by 30 hours, I should be giving them 8.66 sick days? That's a lot of math there. Okay.
There's no criteria for how many sick days you give them. You need to give them New Jersey sick leave, which is for every 30 hours worked, they get 1 hour of sick leave. And you need to define what's the lowest amount they can take in sick leave. So can I take an hour of New Jersey sick leave to go to my doctor's appointment and leave the office? They're only eligible to receive 40 hours in the year. They're not getting 8 days. They're getting 5 or 40 hours, depending on how you want to calculate it.
Okay. Elaine asks, if the corporate office is in New Jersey and you have employees in numerous other states with other leaves besides, which other leaves besides FMLA are these employees eligible for?
Well, we looked at your NJFLA is required for them. New Jersey sick leave is required for them potentially. That the verdict is still out on that. Your workman's comp would not. They would need to pay workman's comp to the state that they're working in. Other than that, you would need to know what those leave laws are and what are their opportunities for that.
Cool. Debbie asks, on New Jersey sick leave, if we change our policy to PTO, can we still use the anniversary date?
No. Even if you're changing it to PTO, if it is going to cover them for New Jersey sick leave, it is one period of time frame for all your employees. It can't be my hire date and your hire date and Tom's hire date and Bob's hire date. It's got to be January to December, February to January, July to June, etc.
Pillar asks a confirming question. Want to confirm that under NJFLA, employees cannot be required to use their PTO, correct?
For NJFLA, let's double check here. It can be required, but it's not. It's up to the employer if they want to require the PTO to be utilized or not, and that needs to be in your policy then.
Okay. Another one from Pillar, who asks, oh, sorry, somebody asked a question and it moved my whole screen. Are agencies not based in New Jersey with employees in New Jersey required to provide NJPSL?
Yes. At this point, yes. Regulations have been questioned on that, and there's been no response. So at this stage, the recommendation would be to do that and not get yourself into trouble.
Okay. Chavi asks, Are there any times where we'd need to voluntarily offer protected leave for an equivalent to a family member? Or do all leaves with this equivalent requirement also necessitate that the employee specifically request the applicable leave protection? It would be difficult if we need to pick up on it without the employee naming it, as we do for FMLA with such a vague equivalent requirement.
Yeah, they need to give you some sort of notice to be clear as to why they're taking it, because, and that you can require in the one area, if you recall, you can require them to get a doctor's note from the family member's physician kind of thing. And I know that, you know, that sounds odd to a certain degree. They have got to give you an understanding. If you're talking about specifically like NJFLA, you need to know what the specifics are. Now, clearly, if someone has a child, you'll know that. But if their mom's sick or their dad's sick, they've got to give you a reason. You know, if I come to you about FMLA, I'm going to give you the reason it's required. There's documentation that we both have to complete in order for that to occur. NJFLA doesn't have a state form. I'm suggesting you go to an attorney. I guarantee you on there, the question is going to be, why do you need to take NJFLA?
Chavi says, to clarify, I mean, if someone says, I need 3 weeks off to give my best friend moral support, do we need to see if that fits under NJFLA?
I would ask to state that, to be very honest with you, because my rational brain is saying that's not a legitimate reason. Not that moral support is a bad thing, but this is more along the lines of the health and welfare of an individual. So it requires it to be a serious medical condition. And if you, there's a list on the NJFLA website of what are considered serious medical conditions. Moral support is not an option.
Okay, so now he's saying change that to, so my best friend has cancer. Is best friend an equivalent?
Yes, they're going to be, well, if you consider it a family-like relationship, then yes.
Okay. I got 3 more here, but keep them coming or not. We'll guide the webinar as such. So William asks, for paid sick leave, if an employee calls out 3 consecutive days and cannot provide a doctor's note, are we required to pay any of the days?
You're going to be required to pay it. I don't know if it's in your policy that they're required for their New Jersey sick leave to provide a doctor's note at 3 days, and they can't. I would think that you could discipline them on that alone, not taking the days, but not providing the documentation.
Okay. Christy asks, would we pay an employee sick time if their school closes for inclement weather? So I'm guessing that the school is the employer.
If the school closes, I believe most of the CBAs in public schools have a caveat to that, where the teachers are still paid because of that CBA. And it's not their decision to not be at school. It would be the school district itself making that decision.
Okay, I got one more question here. It comes from Jennifer. And she asks, can you confirm what starts on January 1st, 2019 versus what starts July 1st, 2020?
For which act?
That was all that was there.
I'm betting it's family medical leave, or excuse me, NJFLA. So for NJFLA, this down to 30 workers starts July 1, 2019. Out-of-state employees are included. Public employers, job protection, no income replacement. The July 2020 under New Jersey SAFE is now that they can use wage replacement benefits.
Well, that looks like all the questions we have, so I think it's a good time as any to bring things to a close. Don't forget, all of you will be receiving a recording of today's webinar and the PowerPoint slides via email. Lastly, when you close out of the webinar, a survey will come up on your screen that we hope you'll fill out. so we can best understand how to provide you important information in a webinar format. Our next webinar, Best Practices for Marijuana in the Workplace, will take place December 5th. So by all means, feel free to register for that one right at our website at njbia.org. So until next time, for Judy Saylor, this is Vinny Civitello, thanking you for being with us this morning and wishing you a great day.
Thanks.